Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
And I'm Daniel Boucher.
Welcome to Hull on Estates. You are listening to episode number 666. Today we'll be discussing a recent decision by Justice Sanfilippo on a rectification application and how this might fit into a trend we've been noticing toward the enhancement of tools available to give effect to the wishes of testators. But first, I'd like to welcome you, Daniel, to the world of podcasting. It's a beautiful sunny spring day. It's your first day podcasting. There's a lot to be happy about today.
Thank you for the welcome, Nick. Really excited about today's episode. First one, get into growing trends in the estates litigation.
Great. So the decision we're going to be looking at today is Gorgi. We apologize in advance if we've mispronounced any of these names. The citation is 2023 ONSC 1803, and it's Gorgi and Ihnatowych, or something similar to that. And as we mentioned, it's an interesting rectification application. Daniel, do you mind taking us through the facts of this?
Oh, sure. So the applicant had children, as the respondent did not. And the last will executed in 2009 provided for the residue of the estate to be distributed with 10% of the residue to be distributed among the deceased's grandchildren alive at the date of his death in equal shares. And
without naming those children or grandchildren.
Correct. The grandchildren and children were unnamed. The balance of the residue would be paid, transferred to the issue alive at the date of his death in equal shares. So that would be the children, again, unnamed. Now, notice of objection was filed on behalf of an illegitimate son of the deceased and his two children, so two grandchildren of the deceased, on the basis that he was a biological son and that his children were biological grandchildren of the deceased, and that they were entitled to a share of that portion of the residue. Now, ultimately, the decision found that, or was in fact rectified to the will, on the basis that the deceased had written notes instructing the drafting solicitor to specifically exclude the illegitimate son. However, the drafting solicitor didn't specify that in the will. He just left a blank children and grandchildren. And the rectification ultimately left the illegitimate son out of the will.
Right. So this is one of those interesting, it seems like so many of these rectification decisions deal with drafting error or an error in a will where it's obvious on the face of the document that there's been a mistake, and that creates some ambiguity. So you need to take a look at the extrinsic evidence, which is admissible in those circumstances, and to consider what was actually intended by the testator. This one was, those tend to be the most common rectification matters that we see in the courts. This one was a bit different, where we're really talking about whether or not the testator's instructions were carried out by his lawyer, and dealt with this interesting fact situation where you've got a child who was, I believe, until later in the life of the testator, maybe even unknown to the client, and hadn't been necessarily discussed with his lawyer.
Correct. I think that the only contact they actually had was over the telephone, and there was an exchange of letters at some point, but it was very much until the illegitimate child was an adult and had children of his own that he reached out to his father.
Yeah, and we see so many wills like this where, a client comes to the lawyer, says, I want to leave everything to my kids, to my grandkids. And this is one of those wills where those kids and grandkids weren't named, and inadvertently, people who the testator did not want to include were included without the will having been rectified. And it was kind of cool because in this situation, we saw such clear evidence of those instructions that were provided to the drafting solicitor, and that, had the will been prepared in accordance with those instructions, it would have excluded the child who was born outside of marriage, as well as those grandchildren who were that child's issue.
It was actually quite insightful of the deceased to specify that, because it could have easily been left to the drafting solicitor to include all children and leave it at that. So I suppose for the residue of the estate, it ended well in that sense.
Exactly. This decision also, for those who are listening, it provides a really good review of the law of rectification in Ontario. It highlights some of the most important cases that we deal with when we're assisting clients with these matters as well. And I guess moving on, there are some interesting points, I think, from this decision that we can take as lawyers who are assisting clients with the preparation of estate plans. And I know this is what we like to do at the outset of our litigation matters, but we always like to get a complete family tree from the client. So we know exactly if there's a reference to issue, if there's a reference to kids, we know who those people are. And in a situation like this, obviously encouraging clients to provide you with all the information relevant to what those terms might mean so that the will has the intended effect, that can go a long way.
So having more information is always helpful. It may not be apparent off the outset, but like I said, in this case, it came in really handy.
Absolutely. So I know, Daniel, when we were talking about this decision previously, we had also turned our minds to Section 21.1 of the Succession Law Reform Act, which came in just in January of last year, which was very exciting. That's the new will validation provision. So if there's a document that appears to reflect the testamentary intentions of the deceased, and that and the date of that person's death was after January 1st, 2022, that's a document that can be validated by the court as a valid will. So that's a really interesting development in our law. And at the same time, it seems like maybe we're seeing some expansion of the tool of rectification. In this will that was rectified by the court in this very recent decision, we've got not only the deletion of words, which historically was what the tool of rectification was limited to. You could delete certain words, maybe add a couple words, but here we had several clauses that were effectively rewritten by adding in a number of words, and in order to give effect to the testator's wishes, which were so clearly documented. So I think it goes without saying that, regardless of whether, obviously all wills are prepared without the hope of there being litigation after death to interpret the will or potentially rectify it, but having clear records of instructions, having clear records of intentions, those can go a long way in fixing problems when they do happen.
That's right, Nick. It really seems like a growing trend at this point, with an importance that wills aren't limited to the strict rules anymore, and it might be a bit more expansive as to the specific instructions around and the context of when it was drafted. And so rectification, like you said, may end up defining terms in a will rather than just simply removing them or changing the language slightly.
Exactly. Yeah. So really cool developments that we're seeing in this area, and it's a trend that I'm at least hopeful we'll see continue in the future. So I think, Daniel, that concludes our podcast. And until next time, we want to thank you for listening. I am Nick Esterbauer.
And I'm Daniel Boucher.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page of our website. Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.